This is the case of Estate of Goldberg. Justice Pierce is recused on this matter, and we are pleased to be joined by Judge Rita M. Cornish of the 2nd District. It's an historic occasion because this is the first time in our court's history that 4 members of the court have been female. So you are all a part of history, and I think that says great things about our state, and I think is an inspiration for many. So I feel honored very much to be a part of this. So let's get to the case. A couple of preliminaries before we begin. We've allocated 20 minutes to a side, as is our custom, but it's also our custom to continue to ask questions of you as long as we think it will help us to understand your case. We see oral argument as a great opportunity for us to educate ourselves about your case, your issues, your argument. So we may keep asking questions after your time has run. Don't worry about that. Feel free to respond. Don't worry about asking leave to exceed your time. And any such extra time will not cut into rebuttal time. It'll all still be there, provided we're still asking questions from the bench. So that may mean that at the end of the day, one of you will have had more time than the other. It's merely a function of how many questions we happen to have had of your case. Okay, counsel, let's hear your appearances.
My name is Ryan Hansey, and I am here with Adam Grunewig and Adam Knorr. We represent the appellants in this matter.
Good morning, Cameron Sabin, and I have Josh Cutler, my colleague, with me today. We represent the appellees in this proceeding.
We welcome you all. Mr. Hansey.
May it please the court, counsel? I've introduced myself. We're here because the district court relied on a Supreme Court case called Lindbergh to disqualify the former trustees' counsel. And it's our position that that reliance on that case was incorrect. The district court's reasoning in relying on the Lindbergh case was that it stood for the proposition that when an attorney represents a trustee, it also represents the corresponding trust. The implication being that that attorney-client relationship is formed with the trust automatically. And because the trustees, the former trustees' counsel had represented them when they were the actual trustees, there was a conflict of interest when the trustees were removed, and the counsel could no longer represent the former trustees in proceedings, including for fees owing that were ostensibly against the trust. The Lindbergh case doesn't say anything about automatic relationships. The holding there was that a trust, that the UEP trust, the trust specific to that case, was capable of being represented and entering into an attorney-client relationship and holding a privilege. And so it was, the court looked at the characteristics of the UEP trust and made that determination. But Lindbergh didn't say anything about an automatic relationship. It didn't say the thing that the lower court relied on to disqualify counsel here. And so, because Lindbergh wasn't applicable, the lower court should have looked at other law and other authority to make the disqualification determination. And one of the things that we think the court should have looked at is Rule of Professional Conduct 1.7.
Can I interrupt you for a minute and
Please.
go back to what you just said about
Yes.
Lindbergh? You said that there was something about the UEP trust that the court relied on to make its conclusion that they could form a trust or an attorney-client type relationship with the trust. What is it specifically you think the court relied on in Lindbergh to make that determination?
Well, I can point out the things that the court noted. It noted that the UEP's primary purpose was religious, and it was to facilitate the wants and the needs of the religious organization that it was set up for. It noted that it was perpetual in duration, and it noted that that it was capable or vulnerable, I think the word was used, of having default judgments entered against it. It also noted that in that case, different from here, the law firm of Snow, Christensen, and Martineau had entered its appearance on behalf of the trust expressly. So that was a point that wasn't in contention in the case, where here the lawyers for the former trustees, engagement letters specifically say that they were entering into relationships with the trustees of the trusts, not the trusts themselves. And so I think those are the things. Does that answer your question?
It does. I guess I'm just trying to figure out if that's how I should read Lindbergh, right? Because the court speaks in broad terms initially in paragraph 32 when it just talks about a trust is not unlike a corporation. I'm not sure I definitely agree with that proposition, but that is what the court said. And then the court didn't proceed to say, in this case, this particular type of trust is like a corporation. But it sounds like that's what you're arguing. We should read it as though it's saying a trust like the one, the UEP trust versus all trusts.
Yeah, I mean, Lindbergh isn't the clearest. I think that for sure it stands for the proposition that the UEP trust specifically was an entity capable of entering into an attorney-client relationship. And I think that that could be expanded possibly to say that some trusts can enter into and form attorney-client relationships, but that's not the same thing as saying that all trusts are like corporations or all trusts are so capable of forming an attorney-client relationship or holding the privilege for that matter. I don't think that Lindbergh is that broad. And again, it certainly doesn't say anything about automatic relationships. And so going back to that Rule 1.7, the rule acknowledges that there is a split in authority across the country over how courts have viewed what happens when an attorney represents a trustee. In some cases, they represent the fiduciary only, and in other cases, they represent the trust and its beneficiaries. I would suggest that that latter is a minority position, but nevertheless, it's out there. And so the rule counsels attorneys to be sure to make clear who it is they're representing.
But even if they do represent the fiduciary, aren't they representing the fiduciary in their capacity as trustee? So when we have successor trustees come in, aren't the successor, if the attorney-client relationship runs to the trustee, when we have successor trustees come in, aren't they the new client?
No, because the attorney-client relationship with the trustee, I'm talking about in a personal capacity, not to the office itself.
But I hear what you're saying, but in the actual representation letters, it seemed like it was quite clear that it was in their capacity as personal representative or in their capacity as trustee.
Right.
And if that's the case, isn't the attorney-client relationship with the office of the trustee, whoever that might be?
No, I don't think that's what the rule of professional conduct suggests. And I also think that it is at odds with the overwhelmingly majority body of the case law that I've referenced that says specifically when you enter into a relationship with a fiduciary, whether it's a personal representative or a trustee, you represent the fiduciary only, and those cases are full of instances where the privilege and the successor trustee becomes an issue because they come in with a new attorney. And I don't think that the rules would ever require a lawyer to be forced to have a new client every time the trustee or the fiduciary is replaced by whatever circumstance by virtue of an engagement letter when that wasn't the intention.
Well, and I'm sure that,
Yeah.
that they certainly could withdraw as counsel. There's certainly nothing that
Right.
would require them to continue representing the successor trustee. But in cases dealing with like the attorney-client privilege and whether the former trustees have to turn over material to the successor trustee, it seems like there's quite a bit of case law saying that if it's dealing with the administration of the trust, the successor trustee does have the right to access that information.
So
How would this be, how is this distinguishable?
okay, the cases out there on that issue normally have used two rationales for getting there. The first, and I would say again minority rationale, is that the beneficiary is the actual client. And so that's why when the fiduciary resigns or is removed, the relationship continues because, and materials have to be turned over to the beneficiary. The more persuasive, in my view, and better reasoning that courts have used for this issue is that in circumstances where a successor trustee comes in, there's a need for the trust's business to be managed and to be administered. Then in those circumstances, the reporting requirement that most states' trust codes have in it to provide information will supersede the attorney-client privilege that existed between the counsel for the former fiduciary and the fiduciary. But even in those circumstances, I'm not aware of a case that when talking about the privilege and versus the privilege of communications versus the obligation to turn materials over to the successor, I've yet to see a case that says, but you have to turn everything over, because they acknowledge a difference between materials, reports, tax returns, things like that, that would actually assist the successor fiduciary in fulfilling its administration responsibilities, and the need to keep protected and confidential the communications on a personal level or that relate to or anticipated or actual litigation involving the trustee and the trustee's counsel. Does that answer your question?
Yes, and I think you're right about that. There can be, the material that's going to be turned over in that kind of situation are only the things related to trust administration. And if the attorney also represented the trustees in their personal capacity, obviously that would still be privileged, or the successor trustee wouldn't have access to that information. But I suppose this whole construct makes me think that maybe at minimum, counsel has two clients here. One is the trustees in their official capacity and potentially also the trustees in their personal capacity. And if that's the case, wouldn't they be disqualified from representing a party that's adverse to the successor trustees?
Well, I think that if the attorney had two clients, then those cases wouldn't be talking about being able to hold back some communications, because if the communications are to the office, and I think that that's a false, I don't think that reflects reality. The rule of professional conduct identifies, who can be a client, and it can be a person, which is a trustee, right? It can be an entity or other organization. It can be a corporation. It doesn't say anything about an office being a client. And I think that that's important. I think it's important to give the lawyer the choice of who its client is going to be. And then this gets to, how does Lindbergh make sense?
Counsel, before you
Please.
move on from
Yes.
this point, if I could just follow up. I'd be interested in an example of an attorney representing a fiduciary as fiduciary, but in a personal capacity.
I thought about this question, Chief Justice, and what I would say if you asked me in which capacity the lawyers here represented the fiduciaries here. And my answer is, it depends on how you define personal capacity, because I don't think that's a bright line. The reality in trust context is that the lawyer is retained to advise the trustees in how to navigate their very complicated and important fiduciary duties. Because if they fail in that regard, they can be exposed to personal liability. And so they're helping them navigate those duties. What do they mean? How can they be applied to the various administrative tasks that the trust has to do? Sometimes beneficiaries are going to disagree with whether the trustee has fulfilled its duties or not, and they're going to threaten or actually file litigation against the trustee. Now the lawyer is helping the trustee defend its actions against those contentions. And so where is the transition exactly from official to personal capacity? I think it's sort of, I don't think it's a real thing, because I think the reality is that when you take on representation of a trustee, you're helping them in both capacities. You're helping them perform their official duties so that they don't run afoul of liability, but you're also helping them in lawsuits or litigation or anticipated litigation, in which case they could be on the hook personally, and they would have to repay whatever damages stem from the breach of trust back into the body of the trust corpus.
So listening to you describe it just that way that you did now, and admittedly, when you're a hammer, every problem's a nail, okay? I'm a former corporate lawyer, but what you've just described to me screams to me, this is a corporation, I have a director, he's hired counsel on behalf of the corporation to advise him on how to run the business of the company. The shareholders sue, bring a derivative claim saying he's mismanaged his obligations, and that manager hires the same counsel that he's been using to represent the corporation. And we have legion case law about how we manage that relationship and the lawyer's duties there. Why wouldn't I resort to that legion of law and just port it over to trusts?
Because trusts, unlike corporations, stem from common law. And you'll remember that one of the important cases we cited in our briefs was the Americold case. It was a U.S. Supreme Court case from 2016. And in that case, I think the U.S. Supreme Court did a really nice job of articulating a reality in the trust context, which is that not all trusts are the same. It's a mistake to lump all trusts together. You can do that with corporations, but trusts are a creature of common law. And historically, the court noted, they can't be hailed into court. They're not a real person. They're not a juridical person. And so what they do, whether they're going to be sued, whether they're going to be sued, when you're determining their citizenship for diversity purposes, that all goes back to common law. It's through the trustee. It's nothing but a fiduciary relationship, is what the Supreme Court said. And so a fiduciary relationship is an ethereal thing. That's why it's not a juridical person. And that's why the trustee is the person who navigates all of the trust responsibilities. And so with Americold and with its progeny, and some of the cases that I'd turn your attention to are the Forefront case, I think, out of the Third Circuit, does a really nice job of taking Americold and running with it and explaining more. Also the Lubier case out of the Second Circuit, and I think it's the Wirtz case out of West Virginia. Those cases look at Americold. These are recent, 17, 18, 19. And they ask the question, okay, we know some of the differences between traditional trusts that are nothing more than a fiduciary relationship and really have to act through the trustee, and other types of more modern trusts that are creatures of statute. And they Americold calls them unincorporated business entities. But those types of trusts, I mean, the court points out, you can call anything a trust, but it doesn't make it a trust in the traditional sense. So you don't hearken back to the common law principles for all types of trusts. And there's a distinction, please.
Yeah, thank you for that explanation. And I take your point about personal liability, how that plays into the analysis. But I am wondering, let's say that we accept some distinction, whether we call it personal or as a fiduciary, but some distinction in two roles of the trustee.
Mm-hmm.
But let's assume that, notwithstanding whatever personal representation there has been, a lawyer represents the fiduciary, the trustee, specifically with respect to the trustee's efforts in effecting, let's say, some transaction on behalf of the trust.
Mm-hmm.
So that while in one sense, the lawyer represents the trustee as trustee, but with respect to the trustee's role in a trust transaction, is not the attorney in that circumstance effectively representing the trust itself?
If it's a traditional trust, then the answer is no, because a fiduciary relationship cannot be a client. And I will be the first one to concede that there are a lot of instances like the one you described where a lawyer's work, or a trustee's work for that matter, will indirectly benefit this ethereal thing that we call a trust. And it's also benefiting the beneficiaries, who are always going to be benefited by trust business getting conducted and administration happening properly and things getting distributed.
Yeah, that's helpful. And let's assume we accept that premise, that certain kinds of trusts are not juridical entities, cannot be sued. Should we be looking to the beneficiaries then? You know, should I be asking in my question, when the trustee acts for the benefit of the beneficiaries, say in effecting some transaction for the beneficiaries, is it fair to say that that trust represents the beneficiaries? Or is it still just limited to representation of the trustee?
Well, again, as Rule 1.7 acknowledges, there is a split. But I think that the overwhelming majority of the cases out there take the position that when you represent a fiduciary, that is your sole client. Now the fiduciary admittedly owes obligations to the beneficiaries. That's a different thing than the lawyer owing duties to the beneficiaries. The lawyer's client is the trustee if it's a traditional trust.
And I take that 1.7 point. I guess what I'm wondering is, let's say you do it right going in, mm-hmm. and you make it clear that the fiduciary is the client. If in the actual present representation things evolve in such a way that you're representing a trust of a certain kind of trust, or beneficiaries, let's say, does that change the landscape?
Well, first of all, I would say this caveat that could only happen in instances where it's not a traditional trust. So if it was I'll call it an entity trust, a business trust or a real estate investment trust, those are things, by the way, that the Utah legislature has expressly said can sue or be sued. They're recognized as juridical persons, unlike traditional trusts. And I'll also point out along the same line that the legislature has incorporated into the trust code the body of common law, and which again says traditional trusts, or trusts in the traditional sense, are not juridical. And so that's been incorporated in, I think it's 75-7-106. But in the cases, to answer your question, in the case of an entity type trust, a business trust or something of that nature, it's also true that a lawyer can enter an attorney-client relationship with just the trustee. Again, it's not an automatic thing that they're going to represent the business trust. It can get its own counsel, or maybe it doesn't need counsel, depending on what's going on in that particular case. But as you've said, I suppose if circumstances morph and the trustee does things that would, that could be considered taking on a new client, then that would have to be looked at. I mean, I think that's very fact sensitive and fact dependent. That's not what happened here, and nor could it, I would say, because of the traditional nature of this trust. And speaking to that point, these cases that have interpreted Americold, the way you answer the question as to what type of trust it is you look at its primary purpose. Was it created by the settlor or the trustor for the purpose of, with donative intent, for the purpose of facilitating donative transfers to the beneficiaries, for the purpose of divesting wealth from the trustor to the beneficiaries upon the trustor's death, sort of in the framework of an estate plan? That's a traditional trust. And if you're looking at the characteristics of the Goldberg Trust here, they're unquestionably traditional in nature. That everything that I just said applies to the Goldberg Trusts. Stanley and Sandra left their property, every item of property that was put into those trusts.
I do apologize for interrupting, but there are no questions pending.
Oh.
You could go on and use up some of your reply time.
You know what, I apologize. I thought I got a mistake. I thought I was answering a question, but I'll finish my thought. Every piece of property in the Goldberg Trusts ultimately was distributed to a beneficiary. That was a estate plan, and that was what the Goldberg, that Sandra and Stanley designed this trust to do. That's why it was a traditional trust. I'll reserve thanks.
Thank you, Mr. Hansey. Mr. Saban.
Good morning, Chief Justice, Justices, Judge Cornish, Counsel. May it please the Court. I don't want to get far afield from the real focus of this case that is before you. The focus is, should counsel who previously represented and acted on behalf of the trustees and the trust, and I will address both throughout my argument, should they be disqualified now because they're trying to represent the removed trustees in an action adverse to the trusts now? And we submit that they should be disqualified. That's what the district court concluded, and we ask that you affirm that decision. Before getting into the arguments, I want to just take a moment and address the questions of, or the concepts of conflicts of interest and disqualification. The reason those doctrines exist in the law in 1.9 of the Rules of Professional Conduct, 1.7 of the Rules of Professional Conduct, is to prevent the unseemly appearance of counsel playing both sides. It arises out of this concept that you can't serve two masters. If I've served one and I've gotten access to all their information and I've provided advice on their behalf and I'm promoting the interests of that entity, to then switch sides and say, I've now got all that information, I provided that advice that got them where they are, and I am counsel that was critical to their interests, and I'm now going to move over here and I'm going to shoot at them with the very same information, the very same advice, the very same position I achieved by representing their interests before. And make no mistake about it, it's clear here that counsel at issue, the two law firms, Mr. Nelson and Kessler and Rust, for 6 years represented the trustees in their fiduciary capacities. And I appreciate the question over here about the engagement letter. When you sign an engagement letter in this capacity to represent a trustee of a trust, what you're doing is you're representing that trustee in all of the affairs of the trust going forward. And to suggest that you'd have to, in a engagement letter, say, I'm going to represent you as trustee but not the trust, or represent you as trustee and the trust, just doesn't happen practically. What happens practically, and I've spent the better part of my career practicing in this particular field, is you represent the trustees knowing full well that you're going to be representing the trust interests as well. And by
Mr.
the way,
Saban, can I interrupt for just
Yeah.
1 second? When you say you represent the trust interests, what does that mean? Because when I think of a trust, I think of property, right? You assign a trustee to administer the trust, administer the property. It's all built around an agreement and ultimately for the benefit of the beneficiaries. So when you say you represent the trust's interests, are you representing the interests of property, or what exactly does that mean to you when you say that?
That's a great question. And historically, the antiquated view of trusts, the common law view, which is, by the way, Utah, we have our own trust code and lots of statutory codes that deal with trust. But the antiquated view was it was a fiduciary relationship. If you look at the trust code and you look at, council cited the restatement second of trusts, but they didn't cite this restatement third of trusts. And this is what this restatement third of trusts states, Justice Pullman, on your very point. And this is a comment A from the restatement third. Increasingly modern common law and statutory concepts and terminology tacitly recognize the trust as a legal entity consisting of the trust estate and the associated fiduciary relation between the trustee and the beneficiaries. This is increasingly and appropriately reflected both in the language, open paren, referring, for example, to the duties and or liability of the trustee to the trust, close paren, and in doctrine, especially in distinguishing between the trustee personally or in an individual and the trustee in a fiduciary capacity, meaning that my approach and what I think the Utah Trust Code and other more recent cases are recognizing is it's a little silly to view the trustee as being entirely separate from the trust when they're acting in their capacity as a trustee. Because all of their duties, all of their obligations, all of their fiduciary responsibilities are targeted at doing what that trust needs. And so what is a trust? A trust is an entity that holds and that manages and administers. And we noted in our brief that under our Utah Trust Code, you can create a trust for just about anything, to manage property, to distribute things, for charitable purposes. And when we talk about snow, how can snow come to that reality? Well, it's very simple actually, because that trust was created to hold a corpus of property. It's an entity that needed to have somebody manage, to act on behalf. In a corporate setting, a corporation can't act on its own. It has to have agents, and a trust is very similar to that. I don't subscribe to the view that corporate analogy is perfect for this circumstance. There are differences, but in the context of representation and capacity to act on behalf of the entity, they are very closely related.
Can I ask one follow-up? Oh, sorry, go ahead.
Yes.
Just so I can visualize this. So if you're hired by the trustee, that's what your letter says, in their capacity as trustee, but you're the lawyer and you see something that you think might harm the assets of the trust, but the trustee believes that's what needs to be done. Would you have to say to the trustee, I now can't facilitate that, or I need to withdraw from representing you because my ultimate duty as a lawyer is to the trust and to the assets, and because we're in disagreement, there's a conflict? I mean, I'm just trying to figure out
That's a great
practically
question.
speaking how this works.
Yeah, practically speaking, the way I have seen it arise and be dealt with, and the ethical rules are very helpful in this respect, but where I have a client who is a trustee, and I can see, for example, a personal conflict of interest that comes up. They are a beneficiary, for example, and they want a greater share than what they're entitled to, or they want to take an action that I believe is contrary to the trust document. In that instance, it is, the rules make clear, 113, it also applies in the corporate context. If that arises, the advice from the ethical rules is you should consult with that client, advise them to seek separate counsel for their personal interests, and continue, if you can, continue advising them in the context as a trustee. If you cannot, if what they propose to do does not resolve your conflict as counsel with what you think is right and what they are trying to do, you are allowed to withdraw at that point and advised to withdraw if you cannot represent that client. So I think that's the way I've seen it dealt with, Justice Pullman, the most in my career. And practically that, it's hard sometimes, but that doesn't mean we can't do it. We do it all the time.
Just a couple of questions. First, Rule 1.7 seems to contemplate a scenario in which a lawyer does just represent the fiduciary. That's one, I'll let you respond to both.
I've read that rule, and I don't think it's accurate to say that there are only two positions in the world on this thing. I've never met a question in the law that only has two positions, and this is certainly not one where there's just two positions. I think the rule is giving an example of, you could have this situation, you could have this situation, but I don't read it as a non-exclusive list. I read it as, you need to make clear up front what your intention is as counsel. If you intend to represent the fiduciary in the capacity as a fiduciary, you need to tell us. If you're going to be representing more than that or less than that, then you need to try and make that clear.
Yeah, and that leads to my second question. That is that a trust can take various forms.
Yeah.
And Mr. Hansey points to a lot of support for the proposition that we ought to treat a business or entity trust, one that's focused on the administration of an enterprise, different from a traditional or donative trust. Why shouldn't we view these two separate kinds of trusts in that way?
Well, before I get too far afield from that, I just want to, or not to go away from that, I just want to say, as a reminder, that argument was not preserved in the district court, and we've had a lot of briefing about it, but the first time I ever heard it was on appeal here. But to your point, Chief Justice, you will not find in Utah law support for that proposition. So you would have to be making, for the first time in Utah history, a distinction between traditional trusts and non-traditional trusts. What's the problem with that? Well, I cited in my brief at least 8 or 10 different statutes that talk about different kinds of trusts in the trust code. And then you have the trust code itself, which allows for an innumerable number of other kinds of trusts you can create. And the idea that you can somehow say, this trust is traditional because it has a donative intent, that is going to be really, really hard to draw that line going forward. You're going to end up with trusts where there are multiple reasons for the trust, multiple purposes for the trust, where you're seeking to accomplish many things in one trust, right? Maybe you're going to manage business plus you're going to donate money to a charity, or you're going to run a business plus you're going to give some money to the kids. And I don't think that's a workable construct.
Is there a category of trusts
Yeah.
that cannot sue or be sued, or that cannot create an attorney-client relationship?
Well, and to that point, I think I've looked, you will not find in Utah law a case or a statute that says a trust in the state, created in the state, cannot sue or be sued. What you'll find is direction, for example, in the statutes, there is the opportunity in the statutes for, this is 814, Utah Code annotated 814.7 sub, 75.7.814.3, Chief Justice, where the trustee can exercise the powers either in his or her own name or in the name of the trust. And the rules of civil procedure allow, they don't require, they allow the trustee to be named as the party bringing the case. But I cited in my brief a number of cases where the trust is the one getting sued or where the trust is bringing the lawsuit. And you will, if you wanted to do a search in Westlaw or Lexis, you'd find an innumerable number of cases where the trust is the party. And the cases Mr. Hansey's talking about acknowledge that the trust is the real party in interest. So to suggest that the real party in interest cannot be on the pleadings, that feels very much like we're form over substance. What we're really dealing with is the trust, and you're the representative of the trust.
Is there anything in the estate context that would suggest otherwise? And is that a fair analogy?
That's a good question. Mr. Hansey's brief cited most of the cases he relies on are estate-related cases. There are differences. For example, an estate is a court-created function that arises only after death and only through court order opening a probate and appointing a lawyer, appointing a personal representative. And so at that point, that estate remains under the direction of the court until it's closed. A trust can be created through a document today. I don't need court approval. I just sign it up, put something in it, and tell it what to do. So I do think there are differences there, Chief Justice. The one place where I think they are similar is that in the fiduciary capacity that the representative acts, they're very similar in that respect, because everything that they do is binding upon the trust or the estate, or can be. It's not everything, but it can be. And when the trust or the estate need to move or do something, it has to be done through a representative, just like a corporation does. So I think that that's the place where I can see the overlap, but I think there are differences where you would say, I don't think they're similar.
Why can't we look at this in a slightly different way and say that the client is the trustee in the capacity as trustee, like the office of the trustee? And if the trustee changes, and specifically talk to me about those cases where they say a successor trustee, for example, can assert the attorney-client privilege for communications between an attorney and the prior trustee. Doesn't that suggest that it's the office of the trustee itself that is the client?
You
And
can't.
I guess I'm just wondering if that's an easier way to look at it than whether the trust itself is a client.
You've got some issues if you do that, and
Okay.
I don't say that that's wrong, that you couldn't theoretically do the law in that way, but I'll give you an example, Justice. This court noted in the Snow case, it's cited to the federal rules or the Utah Rules of Evidence, 504. And you'll note, as that opinion notes in both the separate opinion and the main opinion, that rule refers to the client representative as the trustee. And the client is therefore the trust. And I'm looking here specifically, Justice, at A7 defines client representative to mean a person or entity authorized by the client to obtain legal services for and on behalf of the client. And then if you go down to subsection C, the client is defined as the privilege may be claimed by the client, and the client here is sub C1, but you go to C4 and it says, or the successor trustee or similar representative of a client. So, and that kind of language appears throughout Utah law. And when I go to the trust code, for example, it speaks of the trustee owing duties, but it talks about the trust as owning claims, as having rights, as being able to pursue claims or have claims pursued against it. And so I'm only suggesting, Justice, that whatever we do, I think needs to be consistent with the concept that the trust is a real thing, and we recognize it in the law as a real thing. It's not just an ethereal fiduciary thing anymore. Within the ways that we do trust now, the many types of trust we create, what we're really doing is creating these legal entities that operate through a representative. And so on your second point of how do we deal with the privilege, well, what I would say there is those cases that we're talking about, I would represent them differently than did counsel. I think what they're saying is that where the office of trustee exists and they are removed from the office of trustee, the person who steps into those shoes assumes all of those rights, all of those responsibilities, and all of those obligations that previously existed for the other person. And so what ought to happen, and the Utah Trust Code says this, is when a trustee steps out, they have to turn over all records to the successor trustee, all records. There's no exception. And not in Utah law, not in our trust code. And the exception that counsel's talking about are states where they have adopted the concept that where the trustee has sought individualized advice from the same counsel, and that has been provided, and there's a litigation, for example, that flows out of that. Some courts in some states, and by no means is this a universal position, but some states, some courts have said, well, in that circumstance, we're going to protect the narrow group of documents that where you sought legal advice from counsel, and I think the recognition is that there's a theoretically separate privilege conversation that goes on there. I think that's a little mushy for my taste.
But even if we did adopt that there was some kind of different attorney-client relationship there, if they were giving advice on things that were to the trustees in their personal capacity. I mean, even if we had that in this situation where Kessler and Russ was both advising them as trustees in their official capacity and personally about their liability, how would that change your argument? Wouldn't they still have represented the trust in some way and therefore would be conflicted or disqualified from being adverse to the trust now?
Yeah, that's a really good point. And what I would say to that is this. I would never have done it the way it was done here. The moment my clients got sued for breach of fiduciary duty, I would have gotten separate counsel. I'd have two counsels involved, one for individualized interests and one for trustee-related matters, if you can. Because now we have a situation where who knows, does this communication pertain to their individualized representation or does it pertain to their role as trustee on behalf of the trust? If they're participating in litigation on behalf of the trustee, but it also incorporates individualized concerns, how do we now, after the fact, clear that up? Frankly, that's a mess, but not one of my creations, thankfully. So, I would have advised Justice that that's the way that you should handle it. Now, there may be a circumstance where, for example, a trustee in the middle of a case seeks advice as a trustee on their own obligations. I don't view that as an individualized kind of counsel relationship. They're just asking for, how do I fulfill my fiduciary obligation? And I don't see that as separate from being a representative of the trust. Somebody's got to do it. And in the corporate context, we do that all the time with the officers and directors of a company. We advise them on their duties relative to the company.
Can I ask a follow-up to
Sure.
that? And I just want to make sure, because I've read so much on this case that I feel like sometimes I've lost track of exactly where we're at. Here, from what Justice Hagan was saying, for example, if in fact they advised the trustee, maybe in a conflict issue, right? Some threats have been made, we might sue the trustee, and so they're getting advice. It's still in their capacity as trustee. It's not something personal to their lives, but it's different than what we need to do to administer the trust. But had advised also on the trust administration, there could be a conflict, and then the argument would be they should not be able to continue to represent. Is there anything in this case, though, that specifically gets at whether people are entitled to certain documents or communications? And I'm just wondering if that's an issue here or not, because whether or not someone was someone's lawyer could implicate both, can you continue to represent, but could also implicate, am I entitled to certain communications? And I'm just wanting to make sure I'm not thinking both are at issue if they're not, or only one is if they both are.
Before you today is not the question of anything about what information there is and who's entitled to it yet. You saw that in some of the briefing that ended up in there.
That's, I guess, why maybe I was unsure.
There is a motion pending before the district court that has not been fully briefed and has not been heard because of this appeal.
Okay.
I sought and was told I would not receive all of the client files for the trustees, for the prior trustees when my clients came in as successor trustees. I honestly, Justice Pullman, don't know what that constitutes. So I would suggest that we really need the district court to, on the issue of whose information is it and what is the information, we really need to know first what it is and have the district court address, can it be divided? Is there some portion of it that falls into one category, individualized representation versus trust? I just am not prepared. I don't think we have that before you.
Which makes sense. I guess the reason I'm asking is because depending on how we talk about this, if we talk in absolutes, right, you are absolutely the attorney for the trust, then presumably all communications, or at least an argument could be made that everything's available. If you say you're an attorney for the trustee, then maybe nothing's available. I mean, it's one thing to think about in terms of a conflict of interest. It's easier to kind of divide a line. But if we started talking about documents, I guess I'm just wondering if we should be more nuanced in how we think about that representation. Because some communications may really be trust-oriented. Some may really be kind of arising out of potential conflicts. And I just don't want to talk in absolutes if, in fact, we end up exposing attorney-client privileged information that maybe should not be exposed. Does that make sense?
It does. And the good news is, Justice, I think there is a statute that deals with trust documents, trust records are to be turned over. You don't need to, I don't think, replow that ground. We have a Utah statute that says what needs to happen. Now, I suspect what will ultimately happen is there will be a question after we're out of your, this court and back in the district court about what are we actually talking about. And so I am sensitive to the absolutes because this decision could have implications on many respects, not just privilege, right? Who gets to retain counsel? And if the trustee is different from the trust, then, and they can go get their own counsel and it can be withheld from the trust and its beneficiaries and its successors, well, then how do we deal with, why are they included in theoretically privileged conversations on the trust part? And you get all sorts of weird, I mean, we cited in our brief a bunch of implications that could flow out of this. And so I think what we're simply asking for purposes in this appeal is, and that's why I focused on disqualification from the beginning. The issue here is, should this counsel be able to continue in the way in which they, with all the baggage that came with it, is it fair, is it right, is it just for them to be able to continue as counsel shooting arrows the other way with that very same stuff, including, Justice Pullman, information that we don't have, right, that they obtained by representing the trust. That's my concern, is I don't think that seems very improper to me, that they can hold on to whatever it was, even if it's trust-related stuff, because we didn't represent the trust. We only represented the trustee, and therefore it's ours, and you don't get to see it. And we have the disadvantage of not being able to know, well, what's under this rock that's going to potentially come our way, or what are we unaware of that could impact the trust, or how do we help this successor trustee decide what they need to go do if we can't have all the information, if we're limited in what we're able to access. So there are significant implications that could flow out of this, but for our purposes, what we're asking is there ought to be a disqualification here, and I don't think you get to those implications if you find or conclude that they represented the trust, at least as it relates to trust administration related things, and therefore they can't continue as counsel in this case.
Okay. Thank you. I appreciate that. Let me ask one last question about 504, because you were just quoting from 504C. One of the things that interests me about that provision is it talks about the privilege being claimed by the representative of a client, right? But it says a client that was a corporation, association, or other organization. When I read that, it could have just finished at client, right? Representative of a client, period. But instead, it includes those three terms. In Lindbergh, of course, the court concluded that it was not unlike a corporation, a trust was. But to me, I just wonder why that language was chosen to specifically refer to a corporation, association, or organization, and if you would agree that a trust is none of those three things. It's something different.
Well, I don't think there's any law that I'm aware of that interprets that specific language. We've looked at that, and we couldn't find anything.
Would you contend a trust is an organization? Let me just ask that.
I think the concept of an organization is a broad term. I would not say they are a corporation. A trust is not a corporation. It's also not an association because we have it's certainly not a traditional association. But an organization, a trust could theoretically be an organization in my mind, because by that term you generally mean it's an entity, okay, which the modern concept I've just read from the restatement, the most current restatement, says entity and organization to me are not vastly different terms. If what was meant by the drafters of this rule was organization means an LLC, right, because that's not a corporation.
Right.
It could have meant some other corporate concept, but if they were going to do that, I think they would have used a less general term. Organization to me is a very general term. I don't know. That's the best I can tell you. What I would, I guess, finally add is I don't think that you can read this rule, though, Justice, to say where you've got trustee down in C4.
Right.
It's clearly calling out a trustee. And the trustee is not the client. You can't read that rule and have it be that the trustee is the client,
Right.
right?
Understand what you're saying.
And so then what do? We throw 504 out in all contexts where there's a theoretical traditional trust, which who knows what that means. I think it's the better approach to me is to say, and this is, I think it was misunderstood in our reply. The reply did not correctly represent our position on this point. Our position is that when a trustee retains counsel for the purposes of administering the trust, that counsel becomes the counsel of both the trustee and the trust. It's not automatic for all purposes. It's not automatic in every circumstance. But where you do that, where I'm seeking advice on the administration of this entity, and I'm the fiduciary through which it acts, that I can't, it's naive to think that counsel doesn't have any responsibility to that trust. That's my view.
Thank you.
Thank you very much.
Mr. Hanson, you have your full reply time.
I appreciate
Also,
that.
just on a side note, on reflection, I feel like I did cut you off too soon. I think you were still fairly responding.
I was trying to.
To my question,
Yeah.
so that was my bad.
Oh, no, please, don't apologize. Thank you for the extra time. And I want to just, while it's fresh in my mind, I want to speak to your point, Justice Pullman. So the clear way to reconcile Rule of Evidence 504 with what we're talking about is this. A client can be a person. A trustee is a person. And so the only time that the language that you were talking about, those three words, comes into play is if the client is one of those things, an organization or something like that. So why can't an attorney enter into a relationship with a trustee who is a person? And if that's what happens, then the privilege follows the person. It doesn't follow some organization that was not the client. And that rule clearly contemplates a scenario where a person can be the sole client. Now, I don't want you to have the impression that what I was saying about the dichotomy between traditional trusts and entity trusts is an archaic one. That is not the case. In fact, the Americold case and its progeny are much, much more recent than the third restatement of trusts. Americold came out in 2016, and the Forefront and the Wirtz and the Lubier cases are all, like I said, 2017 through 2019. This is recent stuff.
Well, what is your best argument, counsel, that you preserve this argument?
So my best argument is that this issue came up in the briefing and an oral argument on the disqualification motion. And in our paper, what we said, and I'm paraphrasing, is that charitable trusts, like the UEP trust, are fundamentally distinct from private or traditional trusts. And then at oral argument, we asked the district court to reject Lindbergh's application to our case because of the fundamental differences between the UEP trust in Lindbergh and the Goldberg trusts, including the ability to sue and be sued. And in response, Mr. Sabin, I think, incorrectly argued that all trusts are like corporations that can assert and defend claims. And so I think the issue was preserved, albeit on a limited basis, but I do think that this court has said in State versus Smith and other cases that we're free to expand our arguments and authority supporting those positions on appeal, and that's what we're trying to do here. I hope you'll take a look at the Huey case out of Texas and the Spinner case, which I think it's Spinner? Massachusetts. Because those cases talk about the attorney-client privilege, and they also talk about how lawyers can never represent a trustee or a fiduciary and also a beneficiary. They're incompatible positions because their interests are different. And so I think that that's an important one. As to the issue of whether or not trusts are like a corporation, I would ask this question: if a traditional trust is like a corporation, then why can't it be sued? Why did the legislature say in 75-7-510, here's the process if you want to sue a trustee? You have to sue, or if you want to sue the trust, you have to sue the trustee in a court where jurisdiction lies with the trustee. If a trust is like a corporation, a traditional trust that is, then why is the only way in 75-7-410 that a trust can be created in the first place is by a transfer of property by the settlor to a trustee? The trustee owns the property. The trustee is the client. The trustee holds the attorney-client privilege with the traditional trust. Those are the provisions. I mean, that's what the legislature said. And so I think that it's telling, and again, they're creatures of common law. That's why I don't like the corporation analogy. Are some trusts like corporations? Sure. I think the UEP trust was sort of like a corporation, and there are other ones like real estate investment trusts and business trusts that have a for-profit purpose to carry on business. But the Goldberg trusts are not that.
Let me ask you a question.
Please.
You mentioned that an attorney would have a conflict representing both the trustee and a beneficiary.
Yes.
Would the same conflict arise if the attorney was representing both the trustee in their fiduciary duties in the administration of the trust and the trustees in their individual capacity if they were being sued for malfeasance?
See, I say no, and I understood Mr. Saban's point. He said something like, you can advise the trustees about their duties all along the way. You should do this to avoid running afoul of your obligations. But what, the minute that a lawsuit is filed, now there's a conflict? Why?
Okay.
That doesn't make sense to me, because you're the one that's been providing the advice that the trustee ostensibly was following. And so it's just I view it as a continuation of the lawyer's engagement to advise the trustee in their job to try to navigate the fiduciary duties.
But courts have made a distinction between, at least in the attorney-client privilege context,
Yes.
right? Between advising on trust administration and advising the fiduciary separate from that in their personal capacity.
But not as a conflict. You're
right.
Yes.
It has not been imported into this. But I guess what I'm asking is, does that suggest, though, that the attorney in some respects is representing the trustee in their official capacity, or the trust, if we want to say it shorthand, and in some capacities them in their individual capacity? And if that's the case, aren't they still disqualified because they have been representing the trustees in their capacity as a fiduciary in the administration of the trust?
I've never seen that issue be raised as a basis for disqualification in these cases. Like I said, they don't talk about it in the conflict context. They're talking about, okay, a fiduciary is out for whatever reason. Now we have to decide what the successor or the replacement fiduciary gets. And the courts, some courts have said, you have to turn over, by virtue of your statutory reporting requirements, the documents and the bank statements and the records and things like that. And that's what we did in this case. I mean, that's not even an issue. The problem comes when we're talking about what the privilege itself is for, which is attorney-client communications. That's different than trust management and administration records. And so some courts have drawn the line at communications, you don't get them. We're extending the attorney-client privilege to the trustee-attorney relationship, and you don't have to turn those over. Some states, like I mentioned earlier, like Arizona, and I think California, have adopted what they call the fiduciary exception to the privilege. And even though in those cases, Justice Hagan, they still draw a line between communications that clearly relate to administrative duties of a trustee, you know, like regarding a lease agreement or a contract or something of that nature. And they extend fully the attorney-client privilege to communications between the former trustee's attorney and the trustee that relate to issues that go to litigation or that go to items of a personal nature, whatever that might be. So, yeah, that's how the distinction has been raised in the cases. But I don't think that's the same thing as saying that there's an automatic conflict when a trustee gets removed because you were somehow representing him in dual capacities. I don't see that connection there, and I don't think that any cases have either. I'm probably out of time. Unless there are any questions, that's all I have. Thank you.
Thank you, counsel. Both the briefing and the oral advocacy in this case really have been superb, and as judges, we very much appreciate that, so thank you to you all. We will take this matter under advisement